SJC-13031, Ted DeCosmo v. Blue Tarp Redevelopment LLC, and SJC-13060, A. Richard Schuster v. Wynn Resorts Holding LLC.
Okay, Attorney Garrick.
Madam Chief Justice, and may it please the court, Joshua Garrick for Richard Schuster in the Encore case, and I'm prepared to speak on behalf of both cases here today. The answer to the certified question is no. We ask that the court follow the lead of Judge Burroughs and hold that the rules of blackjack require payment at 3-to-2 odds. We rely on rules 3E, 7A, and 7B, as well as the equipment regulation at 205 CMR 146.13 that clearly and unambiguously state that all blackjacks must be paid at 3-to-2 odds. Not once.
Counsel, I'm going to go ahead and interrupt you because we're going to get right to the heart of it. Those provisions that you mentioned are certainly more general than the specifics in 7D. How is it that if we were to credit your argument, wouldn't we be reading out 7D? Wouldn't it just be a nullity?
No, Justice George. So the first part of that question is the language in Rule 7 more specific? And no, it's not. Rule 7 talks about the payment of blackjack in A and B, and then it goes on to talk about insurance wagers in C and D. And so to suggest that 7D is a specific rule as opposed to a more general rule of the payment, that just doesn't follow from the rules. But to
if you look at the plain language of 7D, it explicitly provides that you can pay these odds without playing the 6-5 variant. Would you agree? Would you agree with that?
No, I think that what 7D says, and I think what the casinos do is they artfully craft their briefing here to suggest that that they're only reading half of the sentence. The second half of the sentence says 7C is void. That's what that sentence means. That's what that provision means. And when we get there, so 7C, of course, is this even money insurance wager. Right. So read as a whole, if we do what Encore wants us to do, and we get halfway through the sentence and make a hard stop, then I suggest that we would have a little bit more difficulty here. But that's not what the sentence says. The sentence goes on to say that 7C is void. That's what 7D means.
It does, but written into that same sentence, though, is the idea that you can play blackjack at odds of 6-5 without playing the 6-5 variation. It may lead to a conclusion that the 7C is void, but it contemplates that the licensee can play this type of game, doesn't it?
Well, so if we're to assume that that's correct, the problem that we run into is that it will effectively render not just 3 other rules of the game completely meaningless and superfluous in 3E, 7A, and 7B, but it also will render meaningless this equipment regulation at 146.13. If there was this so-called option to play 6-5 without using the 6-5 blackjack variation, as absurd as that sounds, they would need an equipment regulation that allows them to use equipment on a 6-5 game that's not using the 6-5 blackjack variation. They haven't neither of the 2 casinos nor the Gaming Commission have reconciled that. I think the Gaming Commission's amicus brief on the topic is pretty appropriate here. They say, you know what, there seems to be some tension here. So we acknowledge it, but we've now since amended the rules. And so that's how we get around it. There's no explanation how these clear and articulate rules versus this, I think we can all agree it was a poorly written rule in 7D, but the other rules are clear and unambiguous. There's no explanation as to how these other clear and ambiguous rules would be not rendered anything but meaningless.
What about the next sentence, Mr. Garrett? Because doesn't that also make Justice George's point? The second sentence goes, so the first sentence, if the licensee chooses the option to play blackjack at odds of 6 to 5 and doesn't use the 6-5 variant, and then section C is void. But then there's the next sentence. If the licensee uses this option, isn't that clear on a 6 or 8 deck? Because that's a 6 to 8 decks is the 6 to 5 without the variation, right?
Correct.
This variation's rules must be displayed on the layout in plain sight. So isn't that clearly saying just what Justice George just asked, which is they've contemplated this. They just want you to put the rules out for you.
They may have contemplated that. And I think that with the benefit of hindsight and the 2 post hoc interpretations of the Gaming Commission, that certainly may have been contemplated. But the proof has to be in the pudding. These rules of blackjack are expansive. They span 41 pages. All of the rules of standard gameplay are outlined in sufficient detail. Rule 6 talks about procedures for how to deal cards. 6A talks about, at length, these procedures for the 6 to 5 blackjack variation. There are no other rules. There's no other mention of this so-called option to play 6 to 5 without using the 6 to 5 variation, other than this inarticulate rule in 7D.
What is the difference between a 6 to 5 and a 6 to 5 variation? Isn't it, there are a couple of differences, right? One, you use a bigger deck, you use lots of decks of cards, and some of the cards are dealt out down rather than up. Is that what's the difference between these 2 variations?
So I think the main variation is it uses no more than 2 decks of cards, as opposed to standard gameplay, which can be between 6 and 8. And that significantly lowers the house edge. And it makes sense. If you're gonna pay out less than what blackjack has always been paid, well, you got to give some benefit to the player. And I think what happened here is the casinos had aggressively lobbied for this 6 to 5 variation. The Gaming Commission said, all right, we'll give it to you, but you've got to give something back to the player. And they came up with Rule 6A, which essentially reduced the amount of decks. There are other rule variations.
Okay, but let's just go to the table we're dealing with. Did it play with a reduced number of decks, or did it play with the same number of decks?
It played with 8 decks, not the reduced amount that would be required under Rule 6A.
So it wasn't a 6 to 5 play, it was a 6 to 5 variation, or which one was it?
It wasn't the 6 to 5 variation.
So it was the 6 to 5.
It paid 6 to 5, but it was under the standard gameplay rules.
And can I ask another question? Isn't everything obvious to the big difference to the player is the 6 to 5? That's posted, right?
I'm not sure that's alleged in either of the 2 complaints. That's a factual issue, but let's assume that it was.
Assume it was. So then the other differences between a 6 to 5 and a 6 to 5 variation, are those also completely obvious to the player? Meaning there's a machine shuffling all these decks and they know it's not just 2 decks and that the cards are being dealt down. So is everything apparent to the player?
Well, Justice Kafka, that raises a good point.
I'm not James Bond. I don't know the rules of blackjack when I get to the table, but isn't this variation issue, is it meaningless, the difference between posting the odds and these other rules to a player?
Yeah. I mean, look, you kind of answered my question, which is the average player, especially if they're going to lose their money at a 6 to 5 table, doesn't know the rules. And they don't know that they have the right, that if they sit at a 6 to 5 blackjack table, that they have the right to be dealt 2 decks of shoes, a shoe of 2 decks, because those odds would be more beneficial.
Your answer, counsel, assumes you assume the premise of the question that you're posing in your answer to Justice Kafka's question. You're assuming that there's only the 6 to 5 variation available.
Correct. Now,
hold on one second.
Attorney Dennison has left the screen.
Oh, it looks like we lost someone. I don't want to.
it'll make my argument easier.
You like those odds, right?
Very good, Justice Seifer.
Wow.
We're not letting you play solitaire, Mr. Garrett.
Can you hear us, Attorney Dennison?
Yes, thank you. It appears you're waiting for me and I appreciate it. And I
Oh,
I
no
drop
problem.
out. Much appreciated.
Okay, Justice Seifer, if you remember, can you repeat your question?
Well, my question was in response to Justice Kafker's question. It seems to me that that Attorney Garlic, I'm sorry, Garrick, assumes that the only game that can be played 6 to 5 is the 6 to 5 variation. But if that's not true and there is another variation possible, what's the answer to Justice Kafker's question?
Okay, so first, I think it's safe to assume that the only permissible 6 to 5 game would be in the aptly named 6 to 5 variation. But to answer Justice Kafker's question,
But why is that?
because why would you have a set of rules that talks about 6 to 5 if you didn't have to follow them? In other words, the amended rules that the Gaming Commission came out with 2 months after the Schuster decision was given was it eliminated the 6 to 5 variation because they've now allowed you to play 6 to 5 in standard gameplay. So if they say that the rules were done for clarity, not to create a new set of rules, well, to answer your question, Justice Seifer, if they weren't changing the rules, they were just clarifying, well, they could have kept the 6 to 5 blackjack variation.
Okay,
So isn't one of your points, though, that with 6 to 5, without a 6 to 5 variation, the regulations don't answer what's imprinted on the table?
Yes, one of the and that goes back to what Justice Kafker was asking, which is if the second sentence says you've got to post the variations rules on the tables, I think his question was, well, aren't all the rules self-evident so that you really don't have to post anything other than the odds? Well, there are a ton of rules that are built into the 41 pages of text. Rules regarding surrender, insurance, double down, split. All these variations differ based on the option that the casino is offering. So to suggest that only the odds or the payouts needed to be put on the table, it completely ignores all of the rules of the variation that need to be posted.
I want to ask you what we do with the Gaming Commission's view here. That's the regulatory body, because what we have here is a mess. We have 7D saying as explicitly as could be, as Justice George has said, that if the license chooses the option to play a blackjack at odds of 6 to 5 and doesn't use the 6 to 5 variation, there's not much room in that sentence. On the other hand, we have that is a sentence about no even money insurance, and you do have these other provisions that talk about 3-2 unless you use the 6-5 variation. And it seems unfair to use 6-5 if you're not doing the 6-5 variation that is more beneficial to the player. So we got a mess here. So let's look at what the Gaming Commission has to say. Now, you take the opposite view of the defendants here as to what we should take from the change in the regulations. Why is your view better? And what about the amicus brief in the other case? Doesn't that say something about their view?
Well, certainly the Gaming Commission is entitled to their view. After all, I agree with you, Justice Lowy. This is a mess, that this is a inarticulate rule, but an inarticulate rule doesn't mean that it's an ambiguous rule. And in order to get to agency deference, we have to have bona fide a truly ambiguous regulation. And what
the best you're going to do is ambiguous with 7D.
Well, I don't think we even get that far, Your Honor. Before we get there, it's incumbent on this court not to, well, what the casinos are asking is for what some commenters have called lazy deference, which is, well, this is what the agency says, so let's just adopt it. But this court and the US Supreme Court have said that that the courts have to do more. The courts can't abrogate their duties here because it's their responsibility to figure out what the law is. And before you get to agency deference, you've got to use every tool in the toolbox to interpret that regulation in an unambiguous manner. And 3E, 7A, 7B, those are all unambiguous.
Yeah, but those just talk about different payouts with different variations of different games of blackjack, and 7D does the exact same thing.
No, 7D says that even money is void, and I think the difference.
Well, it says even money is void, but it also presumes into that sentence that you can play the 6-5 odds, pay the 6-5 odds without playing the 6-5 variation.
Well, assuming that's this mess that Justice Lowy was talking about, that there's this ambiguity, well, the Gaming Commission is entitled to no deference or as little deference as possible. And here's why. Again, we say that it contravenes the plain meaning of the regulations. It comes to an absurd result, but also Justice Lowy asked, well, how do we reconcile the two views of the legislation, the new rules, the amended rules that came about? Well, an opinion can't be used as a de facto way of legislating. So that's what happened here. But because these opinions were given in an amicus brief a week before this hearing and a preliminary finding, which never went final, which was issued 72 hours after we filed the case without ever contacting us for our side, under Skidmore deference, under the Kizor versus Wilkie case out of the United States Supreme Court from 2019, there's no entitlement to deference here. And if there is, all we have is this respect based on the thoroughness of the decision. And the thoroughness and the accuracy of their interpretations, it just doesn't make sense, because up until this point, no one has ever been able on their side to reconcile the conflict with rules 3E, 7A, 7B, and the equipment regulation that says you can't use the equipment that you used when Mr. Schuster was playing blackjack.
So can I ask, all the rules are exactly the same at this table as at the 3-2 table, right? They're all exactly the same, except for it pays out at 6-5, right? Is there? And I assume everyone who's playing all these tables has a basic understanding of the rules of I mean, what you're worried about is the people playing this table are going to be taken advantage of, right?
They absolutely were taken advantage of.
And I'm not sure I disagree with you on that, but the rules again are exactly the same except for the odds. And they are informed they're playing at a cheaper table and the payout's going to be less.
Correct.
So I guess I have trouble, because I agree with you that the second sentence uses the word rules rather than odds. And I'm going to ask Mr. Dennison that. But it seems like the rules are, to those of us who don't play blackjack, this may not be obvious, but it seems like the rules are the same at both tables. The only difference is the odds. So I'm just perplexed why your clients are being cheated in that context.
Well, aside from getting paid the lower odds to which they're entitled to, certainly Judge Burroughs agrees with you, Justice Kafker, that rules mean rules, not payouts. And there are some rules that could vary. Does the dealer hit on a soft 17 or do they stand on a soft 17?
But they do, but the same rules apply at all the other tables. There's no difference between the tables.
Well, I guess I misunderstood your question. I thought the question was with respect to Mr. Schuster, did he play at a table where the rules were the same as standard gameplay? And the answer to that, I believe, was yes. But the casino is not limited in the rules that it can offer here, because this option to pay 6 to 5 without following the 6 to 5 variation is undefined. So we don't know what a dealer does on a soft 17. We don't know what if they can double after a split. We don't know if they can split aces. These are all player friendly.
Isn't that part of what 7D requires disclosure of?
Absolutely. The 7D requires.
So when you say we don't know, in fact, isn't it supposed to be on the felt?
It should be on the felt. And
Okay, so that's what 7D provides.
Right, 7D says that all these rules should be on the felt. They weren't. All that happened was there was a printout of the odds, which is a conclusion that the Gaming Commission stated after the fact.
61 pages of rules, that's going to be a big felt. They're going to have to, basically flash 61 pages on the felt? I mean,
Well, look, Justice Kafker, there are 2 licensed casinos in the Commonwealth of Massachusetts that can offer table games. With that comes great responsibility, because anybody else that offers table games is doing something illegal. It's incumbent on them to make sure not only that they comply with the rules, but if there's any perceived ambiguity, like MGM did, they pulled all their 6 to 5 tables. Encore could have done the same thing. If Encore or MGM or the Gaming Commission thinks that it's too onerous to post all of these rules on the felt, and it doesn't say it has to be posted on the felt, it has to be on plain sight. And sometimes there's placards or screens that can post these rules. And I think typically that's where you're going to see most of these rules posted. If they think that it's too onerous to post these salient rules that affect the player and affect the odds, well, they can use their well-heeled lobbying machine to get those rules changed, just like they've done so here. At the end of the day, they can't explain how their interpretation gets by not only 3E, 7A, and 7B, but they can't get by the equipment regulation. Without that, this court has no choice but to answer the certified question with no.
Okay, thank you. Attorney Dennison?
Thank you, Your Honor. If it pleases the court, Wayne Dennison, on behalf of Blue Tarp Redevelopment, MGM Springfield LLC, that's with respect to the DeCosmo matter, and on behalf of Wynn Resorts Holdings LLC, Wynn Mass and Wynn Resorts Limited in the Schuster matter. I make those distinctions because the distinctions may actually have some meaning here. The Blue Tarp Redevelopment matter is the MGM Springfield matter. That is the matter that Justice Ferrara dismissed on a motion to dismiss, and which is directly on appeal here. The Schuster case comes by way of certification from Judge Burroughs. And let me just start with Judge Burroughs. The suggestion that the appellant made here, that Judge Burroughs has somehow held that all blackjacks must be paid at 3-to-2 odds, is simply incorrect. What
Doesn't that
Judge-
come from Rule 3E? I mean, I thought Rule 3E says standard blackjack shall be paid at odds of 3 to 2 or at odds of 6 to 5 for the 6 to 5 blackjack variation.
Yes, that is in a rule. There is a more specific rule, 7D, and the way that we bring these into accord is there is greater specificity as to the payouts of blackjack in 7D. And that, as Justice George was talking about, is quite clear that you can pay out blackjack at 6 to 5 without using the 6 to 5 variation. My point about Judge Burroughs' decision is that she simply said that the plaintiffs in that case had made a plausible argument. Well, that isn't what is before this court. Judge Burroughs has certified a specific question, and the specific question is, can you pay out at 6 to 5 odds, even though you're not using the 6 to 5 variation? That's the question before this court in the Schuster matter. With respect
And
to
Mr. Dennison, I get there to where you are on that point, that it's hard to ignore the plain language here. But then there's, again, I like plain language, but then I get to the second sentence. This variations rules, which is the 6 to 5 without the variation, must be displayed on the layout in plain sight. And all we've got apparently on the layout in plain sight is that the odds are 6 to 5. So you like plain language. How does that work in your favor then?
Well, Justice Kefker, what that language says, it does say if this licensee uses this option on 6 or 8 deck games. And as you pointed out, a 6 or 8 deck game is not the 6 to 5 variation. This variations rules must be displayed on the layout in plain sight. So Mr. Garrett suggested.
So I take it that we're in this world. They're using big 6 to 8 decks and they're paying out at 6 to 5. And I understand there are 61 pages of rules here. So what do we do with that part of this thing, which is that those rules aren't explained anywhere? Mm-hmm.
So here's what the Gaming Commission did with that. In 205 CMR 14702, it provides that only those table games and their rules authorized by the commission and posted can be played. In CMR 205 146.131, the gaming licensee is required to put a true to scale rendering and a color photograph of the layouts, and they shall be submitted to the Bureau prior to utilizing the layout design. Now, Mr. Garrett suggested to you that he didn't know whether there was a specific allegation in any of his complaints as to what it said on the.
Mr. Dennison, I thought in the Gaming Commission's brief, they just say rules are the same as odds, and posting the odds satisfies that. I'm not sure I'm convinced by that, but isn't that what they said?
Yeah, well, that's what they said, and I think that that's exactly the way they interpreted it from day one, because they approved, as they reflected in their brief, these gaming tables, and this gaming table is alleged in the MGM DeCosmo case. It's specifically alleged in paragraph 59 that on the table it is imprinted blackjack pays at 6 to 5, and MGM in fact pays at odds of 6 to 5 on those tables.
I'm confused, Mr. Dennison. Does the word layout, in Justice Wendland's terms, is layout the felt, or is layout something different? Is there another term of art that I'm not aware of here? What does layout mean? The variations rules must be displayed on the layout in plain sight. What does that mean?
If you go 205 CMR 146.13 again uses that same language, a true to scale rendering and a color photograph of the layout. So I take that to mean that the layout design is what is appearing on the felt.
Mr. Dennison, I'm going to take you away from the specific language and ask you a big picture question. You saw the amicus brief that raised concerns for people who have gambling issues and the obligation of the state in this area. The 6-to-5 odds, plaintiffs said they're not fair because they pay lower odds to players who might be only able to spend less money. And there's an unfairness in that. But there's a greater unfairness going on. And that's that it pushes players to tables with higher stakes that they might not be able to afford. And paying 6-to-5 at the low tables and pushing people who can't afford it to the high tables exacerbates the concern that the amicus brief raised. Is that any factor in our consideration?
Respectfully, Your Honor, I don't think it is. And here's why. We have a gaming commission that has been duly appointed following a vote, following multiple votes of the Commonwealth, of the citizens of the Commonwealth of Massachusetts. And the gaming commission sets the rules for how these table games are going to be played. And the gaming commission, in its judgment, has determined that you can pay out at 6-to-5, irrespective of whether you pay the 6-to-5, play the 6-to-5 variation. In fact, they've since gotten rid of the 6-to-5 variation in the rules starting October of 2020. So I understand your policy concern as stated, but that's a policy concern that has been addressed and is within the purview of the Gaming Commission.
Well, counsel, let's go a little bit further with that. You'll agree with us that the 6-to-5 variation, the rules of that game favor the player.
I don't believe that I can tell you that definitively, Your Honor.
Well, more decks are played in that variation, right?
Fewer decks are played in the 6-to-5 variation. It's only one or two decks.
So, but isn't that designed to up the odds for the player?
The 6-to-5 variation has a whole series of rules that are in 6A about the manner in which the variation is dealt, and a whole series of other ways in which it plays. Mr. Garrick has taken the position that is more favorable to the player. I have no evidence of that.
Okay, what would be the benefit? What would be the benefit to the licensee to pay out 6-to-5 odds without playing the 6-to-5 variation? What would be the benefit?
You can run the game exactly the same way. You can have the dealer work exactly the same way, and every game can be run exactly the same way as every other blackjack table.
So there's no benefit to the licensee. Is that what you're telling us?
No, I think I just identified a benefit, that you can in fact use the exact same rules.
Okay, well, let me then drill down to it. Let's just presume, for the sake of my question, that there is a benefit to the licensee, and we were to say you can pay 6-to-5 odds, but you don't have to play by the more favorable player variation of the 6-to-5 variation game. You don't have to put the rules of the game on the felt, just the odds. So to the unsuspecting casual blackjack player that goes in and sits at a 6-to-5 table, they would be completely unaware that not to use a card reference, but that the stakes are stacked against them.
I don't think
they would be completely unaware that they're playing what they think should be a more favorable game that's being played by rules that are not the 6-5 variation.
This, I think the language that you point to suggests to me that you have to publicize what are the odds of your payouts? What are you going to get if you win? Now, whether an unknowing person comes in and plays 6-5, they know that there is multiple decks being played. They can visually view multiple decks being played. They can visually view that they have a 6-5 odds on the table. There is absolutely no potential for confusion as to what your payout is going to be. And you can make an informed choice as to, I watch this dealer deal from 6 to 8 decks. These are the odds from which I am agreed to play. And you sit down and play. And frankly, what we're talking about is an extraordinarily regulated industry where both of the gaming licensees in this industry go to their regulator, ask them, is this okay? The regulator says yes when they approve the tables. They say yes again when the Investigation and Enforcement Bureau looks at the issue. And then they tell this.
You know, it's this extremely regulated industry says that if you're playing the 6-5 variation, you have to have the odds on the table. This extremely regulated industry doesn't tell us at all what's supposed to be imprinted on the table if you pay off 6-5 without the 6-5 variation.
No, Your Honor, it doesn't. But there's a whole series of CMR rules.
It doesn't, right? I'm sorry, it doesn't, right?
I said it doesn't, but
Yeah,
then I was going to finish my comment by suggesting that there's a whole series of rules out of the CMR that requires pre-approval for what we have put on these tables. And our regulator, in its own brief, indicates that they were approved. And this regulator.
So the record shows, when we go through the record carefully, we're going to see that the commission okayed this 6-5 table without the variation, right? Is that correct?
I think if you go through the record carefully, you will know that the commission had to have approved these tables in order for those tables to have been offered pursuant to the 2 CMR provisions I talked about. And that in the amicus brief, you will see that the commission has indicated that it did pre-approve the tables.
Right. Well, and they pre-approved this 6-5 table without the variation. That's clear?
Yes.
And last question is, does anybody but the industry know the difference between a 6-5 table and a 6-5 variation? Is this common? I mean, from this record, can we discern whether this is a distinction that players know and understand? Because it seems to be inside baseball.
I'm not sure that from this record you can determine that players know or understand 61 pages of regulations or the nuances between the games. We do, from this record, you can, however, discern that the regulator laid out the rules. These casinos both played by those rules and have proceeded accordingly. So I see my time has expired.
One last question, just as a practical matter. If we rule against you, how do you enforce? I mean, is every blackjack transaction taped so that is that how you would pay out this thing? I mean, how do we recreate? How many months was this going on? Is there tape on every blackjack?
As a practical matter, Your Honor, we have actually stayed discovery in the Schuster matter to, in part, avoid the difficulty of determining what is the scope of appropriate discovery. That said, I assume that there are videos available that show gameplay. But you point out
Thank you, counsel.
an
We're all set.
enormous
Thank
discovery
you,
problem.
counsel. Thank you.
Thank you, Your Honor.